Greetings. My name is David Lopez. I am the Co-Dean of Rutgers Law School, the Newark campus, and this is The Power of Attorney. It is my honor today to have Alexis Karteron. She is an associate professor of law at Rutgers Law Newark and also the director of the famed Constitutional Rights Clinic. Alexis, nice to have you with us.
Nice to be here. Thanks for having me.
So I am catching you at a very interesting time in this nation's history. And we have seen, I think, over the past 2 weeks, demonstrations both nationally and globally aimed at stopping police violence against the African American community. And one of the reasons I wanted to have you on the podcast is because you have a background in issues of police brutality and many of the legal issues surrounding policing. So thank you for joining us on a moment's notice.
Absolutely. Very happy to do it.
And so I'm wondering if to start out, you can tell me a little bit about yourself.
Sure. Well, I went to law school wanting to be a civil rights lawyer, and I had a dream of working at the NAACP Legal Defense Fund. And I was very lucky to have that dream come to fruition. After law school, I clerked for a federal judge in San Francisco on the Ninth Circuit. And then I did a fellowship, which allowed me to spend 2 years working at a law firm and then another 2 years working at the Legal Defense Fund, which was an amazing job. I focused on voting rights while I was there. Then I went off to work at the White House for a little bit after that, for about a year and a half at the beginning of the Obama administration in the staff secretary's office. And I really missed being a lawyer. So I decided I was going to go back to civil rights law. And my next stop was the New York Civil Liberties Union. And at the NYCLU, that's when I began doing a lot of police accountability work, suing police officers, working on other advocacy projects that were particularly related to the role of police in schools, as well as the NYPD's stop and frisk practices.
And that was very important litigation. Let me just ask you, where are you from originally?
New York City, Queens.
Great. And I know that you went to California for law school.
Yes, I did.
And I've met Judge Berzon, with whom you clerked on the Ninth Circuit, and very big fan of yours. So we're really happy to have you on the faculty.
Well, I'm a huge fan of hers. And to all the law students listening, I would suggest that doing a clerkship is an invaluable experience. I learned so much during my clerkship that has stayed with me for more than 15 years now. And it's a wonderful experience. I highly recommend.
And can you talk a little bit about the work that you did in the Obama White House?
Sure. I was the associate staff secretary. And sadly, the staff secretary's office is one that usually is pretty low profile. It's become a little bit more high profile in recent years because of, I think it's fair to say, some scandals or some interesting news items regarding people in that office. And so the staff secretary's office is the place where all paper that is going to the president flows. And it's very surprising in a way that in the 21st century, the way things work in the White House really rests very much on paper and not emails to the president, not PowerPoints, not things that are uploaded or sent to him electronically, but paper. So all the paper that goes to the president flows through the staff secretary's office, whether you're talking about bills that need to be signed, or you're talking about memos on healthcare reform or Afghanistan, or a memo about a meeting the president's having the following day, or mail from constituents. So it was a really interesting place to be a fly on the wall in some ways during the first year and a half or so of the Obama administration. So I read memos about his meeting with Boy Scouts, and I read memos about what should be included in the healthcare reform bill that ultimately became Obamacare. I also had the privilege of working for some time on the nomination of Justice Sotomayor's confirmation to the Supreme Court. I was kind of detailed to the White House counsel's office for some time, and that was also an extraordinary experience.
And I'm sure that was a really exciting time to be in Washington at the beginning of the Obama administration.
Definitely. I always like to say that I had Obama fever when he was elected, and I just felt like I had to get to Washington any way I could. And by some stroke of magic, I ended up getting this position in the White House and, got to learn and see a lot in that time.
But you missed litigation.
I did. I did miss litigation. So even though it was a really fascinating experience and one that I'm very grateful to have had, my lawyer heart still called for me to return to litigation. And so that's what I did when I left and went back to the New York Civil Liberties Union.
Talk a little bit about your experience at the New York Civil Liberties Union. Of course, I think many of our listeners have heard about the stop and frisk litigation, and I know that you were centrally involved with that litigation. But talk a little bit about some of the other work that you did in the stop and frisk litigation.
Sure. So, as the name suggests, the New York Civil Liberties Union is the New York affiliate of the ACLU. So, whatever kind of work you think of the ACLU doing, that's the kind of work that the NYCLU does with a focus on New York State. So, I would say starting in about 2011, I started working on stop and frisk issues. And in particular, the project that I was working on was litigation focused on the NYPD's practice of stopping and frisking, and sometimes even arresting people in private apartment buildings that were enrolled in a program called Operation Clean Halls. And the basic idea of the program was one that makes a lot of sense, that these were apartment buildings where landlords sometimes thought there were crime problems in the building or there were concerns, and they wanted to give the NYPD access to their buildings so that they could offer support and they could patrol them if necessary. In truth, a lot of landlords signed their buildings up even if there wasn't a crime problem. The NYPD just had open access to lots of buildings. And what happened all too often was that the NYPD would indiscriminately stop people in those buildings when they were walking out of those buildings, while people were checking their mail, while they were waiting for elevators, while they were taking out their garbage. And again, sometimes even arrest them for trespassing when they were doing nothing of the sort. So the larger stop and frisk litigation called Floyd versus City of New York was a case that was filed in 2008. Our stop and frisk case was filed in 2012, and it was a quote unquote related case, which meant that it went before the same judge. And the cases weren't formally consolidated, but a lot of things happened together in the cases at that point. So we had, for example, a preliminary injunction hearing that was focused on establishing that police officers were stopping people simply because they walked out of these buildings or were near the buildings. And everything about the stop and frisk story for buildings in the program was just like what we know about stop and frisk generally. There was definitely a racially disparate impact with Black and Latinx people being targeted for stops. The same was true for arrests. And they did not comply with constitutional standards. So they were not made with reasonable suspicion. And very often people had really traumatic experiences because of the stops made pursuant to the program.
Well, talk a little bit about the process of establishing that the program had disparate impact against Blacks and Latinx people.
This was where, as a litigator, and any listeners who are litigators know that one of your tasks is to become really intimately familiar with the subject matter you're suing about. So one of the issues in our case was that the NYPD really wasn't keeping track of the program in any meaningful way. They did not have even a centralized list of all the buildings that were enrolled in the program. They were kept precinct by precinct. So we had to employ the services of experts who could gather the relevant data. We had to get all the lists from the NYPD of the buildings, and then they had to geocode those addresses so they could then compare them to data on stops and data on arrests. And so, for example, they had a general stop database that had information about people who were stopped and where the stops occurred, and it basically had to be matched with the data about the buildings that we were focused on. And so then they were able to do an analysis after all that to look at what the racially disparate impact was. I would say, before we got the data in discovery, we really knew that there was a disparate impact just because of the investigation that we had done for more than a year. We talked to tons of people who lived in buildings in the program about their experience. And I think it's fair to say we never encountered a white person who had had one of these bad experiences of being stopped and harassed by the NYPD simply because they were in or near one of these buildings. And the more we dug into the data and discovery, we found that suspicion was absolutely true.
And that's one of the things that sometimes law students have to learn about civil rights litigation, that you're dealing with really pressing issues, but putting a case together can be a very meticulous and painstaking process.
Yes, I could not agree more. Meticulous and painstaking sounds exactly right. We ended up co-counseling the case with the Bronx Defenders, which is a public defender agency in the Bronx, and also Latino Justice and a law firm as well. So, partly working with the public defender agency was really important because they see so many cases of people who have been mistreated by the police in some way or another. So, even if they can get a case dismissed, which is great for their client in terms of the criminal charges, that doesn't necessarily address the civil rights concerns. So, working with them was an enormous benefit because they were on the ground getting clients all the time who had been falsely arrested as a result of these illegal stops. But yeah, it takes at the very least months. It definitely took us, I would say, over a year to get the case ready for filing.
And how did the case turn out?
It turned out pretty well by the standards of litigation. And I think, it's fair to ask ourselves now whether it turned out really well in the long run. But just in terms of, litigation chops, we filed the case. And then a few months later, we had this preliminary injunction hearing that I mentioned that lasted about a week, which was basically a mini trial. And so, we had our clients testify about their experiences, and the officers who stopped and or arrested them, testified in their defense. It might be worth it just to share a really quick story of one of the plaintiffs to give a sense of what happened. One of our clients, he was going to visit his fiance in a building, and he headed over to visit her as he usually did. He pressed the buzzer. She didn't answer the buzzer. He never even actually entered the building, but there was a police officer who was watching from the street and basically called out to him as he walked away from the building and said something to the effect of, "Hey, what are you doing in that building?" And he explained that his fiance lived there and he was attempting to visit her. And next thing he knew, he was being arrested for trespassing in the building. But even, that first interaction is one that is hugely problematic, even putting aside the arrest. Why did the police officer think it was appropriate to stop him and question him when all he was doing was trying to visit someone? There was no indication that he was engaged in criminal activity, but somehow he ended up arrested. He was a security guard, and being arrested automatically triggers a review of your peace officer license in New York State. So he got a notice saying that his peace officer license would be suspended 6 weeks after his arrest, and his court date was not scheduled to be, I think it was about 2 months after the arrest. So he was in an absolute panic that he was going to lose his job if the case weren't resolved before then. Luckily, he was able to get it resolved before then. And luckily, the Bronx District Attorney's Office ultimately agreed not to prosecute him. But it was really emblematic of these problems of police officers interrupting people's days in ways that had enormous consequences. That I think, frankly, my sense was from a lot of the officers we deposed and who testified, I don't think they really thought of it as that big a deal. They weren't physically violent to our clients, but the turmoil that erupted and the trauma that was imposed upon our clients was still very substantial. So in terms of litigation, so we won the preliminary injunction motion. The court issued an order saying that the NYPD had to adopt a policy making clear that officers could not stop people simply because they were outside of the buildings or near the buildings. Ordered a series of reforms like improving their training, improving their supervision, again, adopting a policy, updating their data collection practices. And we ended up, I would say, spending, what year is it, 2020? So we won that case in 2015. 2013. And 7 years later, that case is still being monitored. And yeah, it was a total win from a litigation perspective. I think the question of whether it actually was a win in terms of fundamentally changing the NYPD's practices, it's probably still an open question. I think a lot of things have changed, but the events of recent weeks shows us very clearly that the NYPD has not fundamentally changed. There have been concerns about the disparate impact of their policing with regard to social distancing. And also, what we've seen from the protests in recent weeks, the kind of violence that's been unleashed by the NYPD is certainly not in the spirit of the litigation that so many of us spent so many years toiling over. And I think it really goes to show the limits of litigation as a tool for solving issues with policing. The problems are so much more fundamental.
And I'm sure it felt particularly good for you as a New Yorker coming back home and being involved in such an important case.
Yeah, there definitely was something special about bringing that kind of litigation in communities of color in New York City, like the one I am from. At the same time, it took me a while, I think, to really recognize and understand the limits of that litigation. And after years of meetings, I would say after the litigation, I used to regularly attend meetings with no fewer than 25 people, mostly lawyers, sitting around tables trying to hash out details of policy and the PowerPoints that would be used in training sessions, and the precise wording that would be used, and the terms of a body camera pilot program, all kinds of stuff. I won't say that it was for naught, but it definitely was limited in its real impact.
And I want to drill down a little bit more on some of the limits of litigation. But first, I want to go back to something that you said earlier that I think is really important to talk about at this moment. You talked about the turmoil and the trauma of the Black and Latinx individuals who were arbitrarily detained by the police. Do you want to talk a little bit more about that?
Sure. I think part of what motivated me to keep moving on the case, even when it at times seemed like the result ultimately wouldn't be all that satisfying, was that I did want to get a measure of justice for our clients. And, even though, and I've been thinking about this a lot lately, given the news around police killings and uses of force, but I've been reflecting on how traumatic so many things are, even when nobody lifts a hand to you, even when, you're not beaten up or tragically killed, but when your liberty is taken away, when you find yourself, completely in the hands of people who have total control over you and you don't have anything to say about it. So some of the stories of my clients that really stand out were just extraordinarily abusive. And again, not physically abusive, but I think were just completely unjustified and frankly were shocking. So one client who I think of, he was walking home from his local pizza shop. He had a pizza he was bringing home to eat for dinner with his fiance. He saw somebody that he knew along the way and stopped to chat with him for a minute. And the next thing he knew, a police officer jumped out of a car and asked him what he had just given to the friend he encountered on the sidewalk. And he was like, "What are you talking about? I didn't give him anything. I'm just going home with this pizza." And the officer eventually ordered him to go and sit in the lobby of a building and just wait there for a while. And he did. And he found himself being like, "What am I doing here? This is ridiculous." And so he continued to protest. And the officer ended up arresting him for trespassing him inside the building that he had ordered him to enter. His case lasted for, I think it was about 10 months, if I remember correctly, that he had to, go back and forth to court many times. His job was in jeopardy, having to take off from work every single time he had to go to court. And obviously, there's just the uncertainty of being charged with, a crime and not knowing how the case is going to turn out. And, these were all the clients in the case. We had, I think, 13 clients in the case, and their stories were all very similar to this. People who were just going about their day and found themselves under the eye of the NYPD. And some of them had these really terrible outcomes that I think it's hard for a lot of us to imagine. And again, our clients were all Black and Latinx. And it left all of them with a very bad taste in their mouth. It left all of them feeling like they couldn't trust the police. It left all of them feeling like they wanted to avoid them as much as possible. So the effects of police abuse can be very significant and long lasting, even when you are not subjected to, a taser or pepper spray, a baton, or a gun, a knee, or fists. It's really long lasting.
And it seems like a lot of what we've been seeing over the last couple of weeks is really just the uncorking of community outrage over this type of longstanding treatment. And we're hearing the voices. And I think with litigation, the stories often get, I think, sanitized with technical legal terms. But I think that what we're seeing right now at this moment, it feels like what we're seeing is really this anger and this trauma being expressed nationwide and globally.
Yeah, I think that's right. And I think for a lot of people, there's also a sense that, the police are just involved in way too much. And the police insert themselves into situations where I think if we were really designing a system from scratch, nobody would think, oh, the person I should call right now when my teenage son is having a mental health crisis, the person I should call is a police officer. But because the police presence is so significant in so many ways, that ends up leading to a lot of bad outcomes, which causes the kind of anger and hostility that we're now seeing boil over.
And I want to talk more about your thoughts on the value of litigation. I think that Mayor de Blasio was elected partly on a platform of police reform, and he's come under, I think, intense fire recently, not only as a result of some of the disparate impact of the social distancing stuff, but also about the conduct of the New York Police Department during the protest itself. And in a way, this seems to highlight the almost intractability of this problem in terms of really being able to make a difference in police accountability and ensuring that the police departments do not conduct themselves as they're viewed by many as an occupying force.
Yeah, I think that's right. Mayor de Blasio, when he ran for mayor, he absolutely made his opposition to the NYPD stop and frisk practices a centerpiece of his campaign. There was a commercial featuring his son, Dante, that became very prominent, where Bill de Blasio basically said that he understood the concerns about stop and frisk because he had a black son with a big afro who he worried about vis-a-vis the NYPD's practices. And I will say at the time, for those of us who were very engaged in confronting the NYPD about their discriminatory, unconstitutional, and often illegal, otherwise illegal practices, it was really a breath of fresh air. Mayor Bloomberg had been a staunch defender of the NYPD, seemingly no matter what they did, whether it was about stop and frisk, it was about surveillance of the Muslim community, a whole host of things. He always defended them full tilt. So when Mayor de Blasio, now Mayor de Blasio, in the primary came out so strongly in favor of confronting the NYPD and vowing to end their discriminatory practices, it really did feel like a major change. In terms of litigation, it was also a major change. The week after Mayor de Blasio won the Democratic primary, that was when several police unions in New York City attempted to intervene in the case because they wanted to they wanted to keep challenging the wins that the litigation teams were racking up, even if de Blasio became mayor. And that ended up being an issue that we had to litigate in the Second Circuit. I argued that in the Second Circuit. And Mayor de Blasio took office in January 2014. And it was immediately after that that we were finally able to enter real settlement negotiations. The city had never even been willing to come to the table before that in a meaningful way. And ultimately, we were able to settle the cases.
So I want to circle back to the stop and frisk litigation and your police accountability work in the context of the ongoing protest movements about George Floyd and policing. But before I do that, I want to just talk a little bit more about your experience at the New York Civil Liberties Union. What other type of work did you do there?
A whole host of work. It was one of really the best parts of working there that I didn't have to limit myself to one subject matter. So I certainly spent a good amount of time working on policing issues aside from stop and frisk. One issue that I spent many years toiling over was the role of police in schools, the constitutional limits regarding the role of police in schools. And that was really important work, which continues to inform my thinking about policing today. And I'm heartened to see that now at least two school districts around the country have decided to sever ties with their local police departments because of concerns about how policing in school unfolds. I also worked on a case about the availability of public defenders or people accused of crimes in upstate New York. At the time, it really felt like there was a completely different world in upstate New York compared to New York City when it came to the opportunity to get representation if one were confronting criminal charges. For example, before that case, it was not necessarily standard for people to have lawyers when they were arraigned, which is, of course, a very important stage in litigation and the first time typically that people are appearing before a court. So we worked on that and generally ended up with a very robust settlement that has significantly expanded the availability of public defenders around the state. I also worked on some First Amendment litigation. I worked on other policing cases. One that's particularly relevant now was a case about the use of a chokehold, another case about the right to record police activity on cell phones, and a whole variety of projects.
Do you want to give a shout out to the executive director who is one of ours?
Absolutely. So my boss for the years I was at the NYCLU was Donna Lieberman, class of 1973 from Rutgers Law School. And I think she certainly brought the spirit of People's Electric Law School with her to the NYCLU and continues to be a tremendous leader there. She's been there for a very long time now, doing and overseeing a huge amount of really important work devoted to protecting the civil rights and civil liberties of New Yorkers. So she was a wonderful boss and mentor, and certainly she's a testament to the kind of great legal education that is to be had at Rutgers Law School, and the spirit of fighting for social justice that we all hope to keep going at Rutgers today.
That was a nice segue, though, because I wanted to talk about your path to Rutgers Law School. Did you play a role in that, or was it just completely a coincidence? Tell us how you ended up at Rutgers Law School.
Well, my last few years at the NYCLU, I was an adjunct faculty member at another law school, co-teaching a clinic, both with a faculty member at that law school and with the associate legal director at the NYCLU. So I kind of got my hands dirty trying out clinical legal education. I had taken a clinic in law school. In some ways, it was kind of a non-traditional clinic in that I was basically placed at a nonprofit and got to do some interesting work on litigation in California. My clinic professor at the time was actually Michelle Alexander, who has come to be quite famous for a variety of work, and in particular her book, The New Jim Crow. So I feel very, very lucky to have gotten my first clinical experience under her tutelage. But when I was at the NYCLU, I, again, was an adjunct. Being an adjunct at NYU was a really great experience. I worked with some students on a variety of issues, actually all related to policing, I think, when I think back on it. So I had clinic students who worked on a case about the right to record police activity. We represented a woman who basically was recording on her phone stop and frisk of a few teenagers on her block, and the cops didn't like it. They ended up arresting her and giving her a ticket, which was unconstitutional. We worked on a case about the policing of homeless people in Manhattan, and in particular, the NYPD's terrible practice of unceremoniously taking the property of homeless people and disposing of it, which again violates constitutional rights. We represented someone who was put in a chokehold by a police officer in the hallway outside his apartment, which is obviously an experience that's on my mind these days as we all react to the killing of George Floyd in Minneapolis, and a host of other projects. So it was a good experience that gave me a taste of what being a clinical faculty member, a full-time clinical faculty member would be like. And when the opportunity opened at Rutgers to potentially direct the Constitutional Rights Clinic, I felt like I couldn't let it pass me by. So I threw my hat in the ring, and here I am. And I've been on the faculty for 4 years now.
That's wonderful, and a very popular professor, I might add. But did you know about the Constitutional Law Clinic before you came over?
Yeah, I did. And certainly Donna, who we've talked about, Donna Lieberman, she had been a student in the clinic. I don't know if it was exactly the clinic in this form, but she certainly had worked with the faculty in the clinic on a number of cases when she was a student. In particular, she worked on the precursor to the Abbott case in New Jersey, which is familiar to lots of New Jerseyans about educational equity. So I knew about the clinic before the position became available. Yes. And again, it seemed like a great opportunity to get to do this full time because it's really a great job to get to do it full time and to, get to spend more time working with students and to delve into the world of legal scholarship. And here I am. It's been a great ride.
That's wonderful, and I'm not sure if our listeners know, but the Constitutional Law Clinic, all of our clinics are great, but the Constitutional Law Clinic is one of the oldest clinics and regarded as almost the crown jewel of all of the clinics, just because it has such a storied history.
Yeah, we've gotten to work on some really great stuff. And it's a really amazing thing to be part of this now 50-year tradition. This year, the Rutgers New York Clinical Program is celebrating 50 years. And so I feel enormously lucky and proud to be a part of that tradition.
Yeah, and talk a little bit about the clinical faculty. It's just a tremendous faculty, and it's one of the oldest clinical programs in the country. Talk about what it's like to work with some of those other professors.
Sure. The clinical faculty is, as you've said, incredibly impressive, working on cases and projects in a huge range of areas. I'm always blown away by the expertise so many of our clinical faculty have in a variety of subject matters. So we have a special education clinic, we have a civil justice clinic that focuses on housing and social security issues. We have a criminal and youth justice clinic. I'm going to get myself in trouble if I try to list them all, so I will not. But I will just say it's a very impressive bunch, a very collegial bunch. I feel very lucky to be in their company and learn from them all the time, and think that students who come through the clinical program, even though they work on a range of topics and very different kinds of cases, I hope they all come away with a real dedication to social justice. We're not interested in legal problems just from a theoretical perspective. We're interested in them because of their real world impact on the communities we serve every day.
And talk a little bit about some of the work the clinic is working on now.
Sure. So, one project my clinic has worked on in the last few months is actually related to the COVID crisis and representing an immigrant detainee at the Essex County Correctional Facility in partnership with attorneys from the Child Advocacy Clinic and the Immigrant Rights Clinic. There's been a lot of litigation attempting to basically depopulate the Essex County Correctional Facility and other jails that are detaining immigrants, because immigration detention is civil. It is not criminal. It is not supposed to be punishment. But of course, being in jail feels like punishment to a lot of people, understandably. So we're working on a habeas petition right now in an effort to help someone get released from the jail. We worked on a project earlier this year in a case that's currently pending at the New Jersey Supreme Court about the availability of civilian review of police departments in New Jersey. So New Jersey just has one civilian complaint review board, and that's in Newark, after a multi-decade history of police abuse without accountability. And the question is really the scope of the CCRB's powers and certain actions that they can take or not take under a constellation of New Jersey laws. So that case is currently pending. We submitted a brief in that case. My clinic tends to focus on issues related to mass incarceration. So we also have an ongoing relationship with the Inmate Legal Association at New Jersey State Prison, which is a group of incarcerated people who represent other incarcerated people. in a wide variety of legal matters. We're also working on a project with the New York Civil Liberties Union, actually, along with Prisoners Legal Services of New York, representing parolees who have been subject to unconstitutional parole conditions. So I think that pretty much probably covers the big projects in the last 6 months or so.
And you mentioned some of the work that the clinics were doing during the pandemic. And I know that the clinics have been just tremendously busy trying to deal with a lot of the consequences of the pandemic on low income communities. And it really has been a thing to witness. Very inspiring, but it's just a tremendous amount of work. And I know that the pandemic really exposed many of the divides that we have in society, and the clinics have really been at the front line and working on all that. But in the midst of all of that really tremendous work, we had the killing of George Floyd and everything that happened after that. Do you want to talk a little bit about that? Because that really, in many ways, went to the heart of what you have been working on throughout most of your career.
I will say it is a very strange experience to suddenly have, it feels like literally everyone talking about the issues that you've been thinking about and writing about and litigating about for 10 years. And that's my reality right now. I mentioned before the case that I once had on behalf of a teenage boy who was put in a chokehold by a police officer outside his apartment in the hallway. And I've been thinking about that a lot because it leaves me with some conflicted feelings about exactly what the path forward is to really transform policing. So instances like the killing of George Floyd never happen again. In New York City, chokeholds were banned by the NYPD in 1995. And unsurprisingly, that ban came about because of multiple people who had been put in chokeholds and multiple people who had died due to chokeholds. So the use of chokeholds is not at all a new phenomenon. And around the time that Eric Garner was killed by a police officer because of a chokehold, when I was still at the NYCLU, I, basically went looking for a case involving a chokehold. And it wasn't that hard to find one. And what that makes me feel like is a ban on chokeholds isn't enough. There's been one in place for so long in New York City, and Eric Garner obviously famously died due to a chokehold, and other people have been put in chokeholds. There must be something more that's required to make sure that the practice really comes to an end, as it surely should. And, in particular, when I think about that case and I think about my teenage client who was put in a chokehold, it wasn't on camera. He did not have lasting injuries. It was still very traumatic. It was traumatic for him. It was traumatic for his family who was watching as it happened and begging the officer who was choking him to stop. And, after he was put in a chokehold and after he was beaten up by multiple officers, he was not further arrested and processed. He was taken to the hospital because a supervising officer on the scene said something to the effect of, well, he can't go to the precinct looking like that. He has to go to the hospital. So he went to the hospital and he ultimately was sent home. And, nothing ever came of it as far as the NYPD was concerned. And I think that getting to the bottom of why these kinds of practices persist, I think the law is never going to be an answer alone because we've had laws, we've had reforms, we've had policy changes, and there's something deeper that has to happen. There's something deeper that has to change for us to really make sure that horrible events like the killing of George Floyd never happen again.
And what do you believe that is?
Well, I won't claim to have all the answers, but one thing that's been on my mind a lot is just how much the police are called into situations where it's wildly inappropriate for them to be the first responders. So, in the case of my client who was put in a chokehold, he was 15, almost 16 at the time, and he had some mental health issues. And at the moment that the police came, it was because they were called by his family. And they had a history of calling the police when they were starting to feel like he was perhaps out of control. And in the past, the police had been a force for good. They helped diffuse the situation, they calmed everybody down. But something changed by the time he was 15, almost 16, and they turned to violence instead. And I've heard this again and again and again from clients, whether it was in cases about police in schools and the way that, say teenagers were treated versus 12-year-olds were treated, or my clients in the stop and frisk case, that once boys, and it was usually boys in these cases, not always, but usually boys who are Black or Latinx, in this case, a boy who lived in public housing in the Bronx, once they reached a certain age, the police came to see them as threats and came to use violence against them regularly. So I tend to think about that family and wish they'd really had someone to call besides the police that day when their son started to act a little bit erratically. And so, I think this is part of what the defund the police movement is about. We're not going to get rid of police tomorrow. I don't think anyone who is a proponent of quote unquote defund the police is saying they want police officers to go away immediately. But it's really kind of about our orientation. It's about how we think about the problems police address, and to suggest there has to be another way. So when I think about my stop and frisk case that focused on the treatment of people in these apartment buildings, it was really striking that very often the landlords turn to the police before they put really good locks on the doors. And in the case of my client who was put in a chokehold, there was no one to call besides the police. So I'm hopeful that this is the start of a really important conversation about what exactly the police are for, what exactly we want them to do, and what the appropriate changes are once we figure that out.
And I think it's a conversation that many are participating in for the first time. And, as someone who is a little bit older than you and has lived through these incidents before, certainly remember the grainy image of the 4 LA police officers beating Rodney King, and sort of the national conversation that ensued after that, which focused on issues of community policing and the use of the chokehold and de-escalation and stuff like that. I think now we find ourselves talking about defunding the police and divestment, and I think for a lot of people, they're trying to figure out what that means and how do you participate in that conversation. And of course, that conversation is taking place in the context of an election year when there is probably an incentive to either obscure or distort what I think the divestment advocates are actually seeking. So do you want to talk a little bit more about resources available for people who are trying to understand that issue, or models that we might look at to understand how policing can be reformed?
Yeah, I think, just to provide a little bit of context, since you mentioned Rodney King, which I am also old enough to remember, I think that after Rodney King, the kind of major reform that occurred was the expansion of federal authority to investigate police abuse, patterns of police abuse. So it was in the wake of Rodney King that the Civil Rights Division at the Department of Justice got the authority for the first time to investigate patterns and practices of police misconduct. And their powers were expanded in other ways so that they could investigate and regulate the police. In the news now, you often hear you talk about consent decrees and, which are basically agreements that are reached typically between the Department of Justice and cities with regard to particular practices. And that was really born because of Rodney King. And, just a few years ago, President Obama had convened a task force on 21st century policing, which had a number of recommendations that certainly I think a number of places adopted. And so the discussion turning to defund the police and reimagine the police is really a result of concern that those changes and those reforms just haven't been enough. And I don't in any way mean to, denigrate them and, consider myself someone who has been a part of them, as someone who litigated these issues for a long time. But I think that, what you're seeing is now just exhaustion and a sense that it's just not good enough. We know that things like, changing the words on the paper about when force is permitted or not is not sufficient to really change what happens on the street. So if people are looking for more information, I would suggest looking at the website for the Movement for Black Lives. That's an organization that has, I think, really been a leader in the conversation about defunding the police and thinking about what that looks like, thinking about, alternatives to policing. There's a bill that just came out yesterday, a federal bill that has, a number of changes that I think a lot of people think are very positive, but there's certainly more that can happen. And a lot of it is going to happen at the state and local level. This is not something that a president or the Congress can, wave a magic wand and fix. A lot of these issues take painstaking work at the state and local level for really effective change to occur. So it's all a work in progress, and we're all waiting to see how it turns out.
Yeah. Let me ask you about another thing that we've been hearing a lot about. And this is going to be almost a quintessential lawyer's issue, but it's something that's very important. And I know that within the building, it's generated a lot of discussion. And that's the whole issue of qualified immunity. Do you want to talk a little bit about that?
So, qualified immunity is a judge created legal doctrine that every civil rights lawyer loathes in the United States. And it's a doctrine that serves to protect government officials and officers. And the basic idea behind it is that when government officials or officers are sued for, say, violating someone's civil rights, that they shouldn't be liable for something that they didn't have reason to know violated constitutional rights. So, one of the joys of constitutional law is that, the words in the Constitution are given meaning by cases that announce new rules, and the law evolves over time. It's not static, it's not limited to the text. So, applying the constitutional standards in different contexts creates new law all the time, every day. Judges are coming out with new decisions. And so, what qualified immunity does is it requires a two-part analysis, arguably a three-part analysis, of whether an officer should be liable for some harm they have caused. And so, the first question that's typically asked is, did this thing that happened violate the Constitution? Did it violate this person's constitutional rights? And you would think that that would be the question that mattered. Did you violate my rights when you put me in a chokehold? Did you violate my rights when you came into my house without a warrant? Did you violate my rights when you took my stuff and threw it out with no notice or any opportunity to be heard? You would think that would be the end of the story. But what qualified immunity does is it adds another question, which is to say, is the right at issue one that was clearly established at the time of the alleged violation? And that has been interpreted by many courts to mean that there has to have been a prior precedent, so a prior case that matches up with the violation that's at issue in the case before them. So basically, the idea is that if there isn't some judge who has already said this thing is a constitutional violation, then this officer couldn't have been on notice that they'd be violating the Constitution if they did it, and we can't hold that officer liable. And so this comes up all the time. And you can imagine that lawyers for defendants, lawyers for government officials, they can use this argument very effectively. And they can say, well, there's no case that's exactly like this that's happened before. So my client couldn't have, possibly known that, this thing was unconstitutional, and therefore they're off the hook. So what that means is that you have a lot of people whose rights are violated, but because there's not a case that came beforehand that is precisely on point and really is a good match for what the plaintiff is alleging occurred in the case before them, the officer is off the hook. And again, like I said, this is really the bane of the existence of plaintiffs' lawyers all over the United States of America. And so there's a lot of concern that, for police officers in particular who use new techniques, who have new technology. It can't, they're frequently let off the hook because there hasn't been something before. So to give an example, like when tasers first came on the scene, there are a lot of cases that raise questions about the appropriate use of tasers. Can you use a taser when someone simply doesn't comply with a police order, someone who's not being violent in any way, not threatening violence, but just, won't do what they're being told? I had a case like that when I was at the NYCLU. And so, when tasers were still really new, there wasn't any precedent. There wasn't any case law about the circumstances under which tasers could be used. So a lot of officers were let off the hook, even if they used tasers in ways that are wildly inappropriate, unconstitutional. Nobody would think it was a reasonable thing to do to use a taser in some particular circumstance. Qualified immunity would let them go. So there have been ongoing calls to abolish qualified immunity, and that was one of the things that was in the bill that the Democrats introduced yesterday.
What are some of the other important legal issues that we should be thinking about these days with respect to police accountability?
Well, as important as qualified immunity is, I always like to say that another issue that I think flies under the radar and doesn't get enough attention is the fact that police officers, more often than not, even if you can get past the hurdle of qualified immunity, even if they are found liable, they don't actually pay when they have been found to violate someone's rights in a civil lawsuit. And so that's because of a doctrine called indemnification. And that's basically protection that employers, so usually a city, but if you're talking about a police officer, offers to its officers to say, okay, if you get in trouble because of something you've done on the job, we'll pay for it. So, don't worry about that. We'll pay for your lawyer. That's usually one component of the protection. And we'll also pay any judgment against you. That's another. Professor Joanna Schwartz at UCLA did a very comprehensive study about this several years ago and found that in, I believe it was 99% of the cases she reviewed, officers didn't pay. So again, these are people who have gotten past the qualified immunity hurdle. So I do think that's an issue that we should be paying very close attention to. Officers generally don't have any skin in the game because they know that they're going to be covered. I should caution, this isn't true everywhere. New Jersey is actually a major example of a place where indemnification is not required by state law, but it is very common generally in the United States. And this really kind of goes back to the idea that, even for people who are very pleased with the reform legislation that the Democratic Party put out yesterday in Congress, these are things that can't necessarily be regulated by Congress. These are things that will be decided on the state level and on the local level. So I would counsel that engagement at the state and local level is deeply important. I think, we're also going to see a lot of changes with regard to use of force standards. Use of force standards, again, are regulated at the state level. So they vary state to state. And I wouldn't be surprised to see some states start thinking hard about what they think an appropriate use of force is. Another area is prosecution of police. In recent years, there's been a lot of concern about the fact that local prosecutors, who often work very closely with police officers, always work very closely with police officers, are the ones who decide when, a use of force or something similar is actually criminal in nature. So in recent years, a number of states have moved toward a more independent model where perhaps a state attorney general or another independent prosecutor is the entity that actually investigates and perhaps ultimately prosecutes uses of force. But I think we'll see more of that as well.
I just think the last 2 weeks have really been probably one of the most notable experiments in American democracy, certainly in my lifetime, but probably in the history of this country. Do you feel hopeful that this will lead to real change, or do you think it's too early to tell?
I feel hopeful that there will be some real change in some places. I don't doubt that there will be a number of places that are really resistant to change. And because so much of the regulation of policing happens at the state and local level, I just think, there's no way we're going to have a wholesale change. All these the circumstances that lead to things like the killing of George Floyd are just so deeply embedded. You can't flip a switch and all of a sudden have, the problems that gave rise to that go away. So I'm a little bit hopeful, but I agree that it's a remarkable time, and it is heartening to see how many people care. How many people are just completely appalled and outraged by the killing of George Floyd, and I hope that that feeling really does manifest into something good for all of us.
What would you say to our students or people considering going to law school to practice civil rights or to make long-lasting reform? What message would you want to leave with them?
I think I'd want to say to them that they should really look at themselves as partners with communities that are trying to affect change. They should be humble about the limits of the law to achieve real change, but know that they have something valuable to add in the fight for racial equality, racial justice, and more fair policing.
Now we talked a lot about litigation experience in your work in the clinics, but you're also a fantastic scholar. So before we sign off, I want you to talk a little bit, give you the opportunity to talk a little bit about your scholarship and perhaps what you're thinking about next in terms of your scholarship.
So my scholarship is about policing. So I've written articles about policing in schools, policing in public housing and other patrolled housing, like that at the center of the stop and frisk case I litigated. I'm working on something right now about thinking about applying a reparations framework to policing, which I think requires thinking harder about how police abuse affects entire communities and not just individual victims. I'm also working on an article right now that's about the need for parole and other community supervision programs to respect the constitutional rights of the people under their supervision. And particularly as it relates to George Floyd, I'm also beginning work on a study of how the legal system responds to uses of force in New Jersey, and trying to figure out, aside from qualified immunity, what are the legal doctrines and the practices in a variety of courts around the state that really matter in learning whether plaintiffs seek and gain redress following uses of force by police.
So you're very busy.
Yes, no doubt about that.
Thank you, Alexis Karteron, Associate Professor, Director of the Constitutional Rights Clinic at Rutgers Law School, Newark, and a tremendous litigator and scholar. Thank you for being our guest today, and I hope the world hears more from you.
Thanks for having me. It was a pleasure.
The Power of Attorney is produced by Rutgers Law School. With 2 locations minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal, small campus experience. Learn more about Rutgers Law by visiting law.rutgers.edu.